Can your employer fire you without any warning in the UK? Imagine this. You arrive at work on a normal Tuesday morning. Your manager calls you into their office, and within 5 minutes, you're being escorted out of the building with your belongings in a cardboard box. No warning, no explanation, just gone. This happens to thousands of UK employees every single year. And the shocking part? In many cases, it's completely legal. But here's what most employees don't know. Whether your employer can fire you without warning depends on how long you've worked there, and the rules are changing dramatically in 2027. By the end of this video, you'll understand exactly where you stand right now, what's changing in the law, and what you can actually do if this happens to you. This content is for general educational purposes only and is not legal advice. For advice specific to your situation, consult a qualified employment law professional in the UK. So, let's answer the big question. Can your employer fire you without warning? The answer depends on something called the qualifying period for unfair dismissal protection. And right now, in April 2026, we're in a transition period where the law is about to change significantly. Here's how it works under current law. If you've worked for your employer for less than 2 years, they can dismiss you for almost any reason, or even no reason at all. They don't need to give you warnings. They don't need to follow a disciplinary process. And in most cases, you have very little legal protection. But if you've worked for your employer for 2 years or more, everything changes. You gain protection against unfair dismissal. This means your employer must have a fair reason to fire you, and they must follow a fair process. If they don't, you can take them to an employment tribunal and potentially win significant compensation. Now here's the critical update everyone needs to know. From January 1st, 2027, this 2-year rule is being slashed. The UK government passed the Employment Rights Act 2025, which reduces the qualifying period from 2 years down to just 6 months. This is one of the biggest changes to UK employment law in over a decade. What does this mean in practice? From January 2027 onwards, if you've worked somewhere for 6 months or more, you'll have full unfair dismissal protection. And here's the important part. If you already have 6 months service by January 1st, 2027, you'll immediately gain this protection on that date. You don't have to wait another 6 months. So if you're watching this in 2026 and you've been in your job for 6 months or more, you're about to get significantly stronger employment rights come January. Why does this qualifying period exist at all? It was introduced to give employers flexibility when hiring new staff. The idea is that during this initial period, employers can assess whether you're the right fit without complex legal procedures. But once you pass that threshold, the law recognizes you as an established employee deserving stronger protection. Here's what many people miss. This time counts as continuous employment with the same employer. If you change jobs, the clock resets to 0. If you take an extended break, it might reset. Understanding exactly when your continuous employment started is absolutely crucial to knowing your rights. But wait, does this mean someone with less than 6 months service, or less than 2 years under current law, has 0 protection? Absolutely not. Even if you've worked somewhere for just 1 single day, there are certain reasons your employer cannot legally fire you. These are called automatically unfair dismissal reasons, and they apply from day 1 of your employment, regardless of the qualifying period. Let me walk you through the main ones. Number 1. Discrimination. Your employer cannot fire you because of your age, disability, gender reassignment, marriage or civil partnership status, pregnancy or maternity, race, religion or belief, sex, or sexual orientation. These are protected characteristics under the Equality Act 2010. If your employer dismisses you for any of these reasons, that's automatically unfair dismissal from day 1. Number 2, whistleblowing. If you make a protected disclosure, meaning you report illegal activity, dangers to health and safety, environmental damage, or cover-ups of wrongdoing, you're protected from dismissal. Firing you for speaking up about serious issues is automatically unfair, even on your first day. Number 3, health and safety. If you raise genuine concerns about unsafe working conditions, leave a dangerous workplace, or refuse to work in circumstances you reasonably believe pose serious and imminent danger, you cannot be dismissed for that. Number 4, asserting a statutory right. This means standing up for your legal employment rights. Things like requesting the national minimum wage, asking for proper payslips, taking entitled holiday, requesting flexible working, or taking family leave, including maternity, paternity, adoption, or parental leave. Your employer cannot punish you for exercising these rights. Number 5, trade union membership and activities. Joining a trade union, participating in union activities, or refusing to join a union are all protected from day one. Number 6, part-time and fixed-term workers. You cannot be dismissed for asserting your rights as a part-time or fixed-term employee, including the right not to be treated less favorably than full-time or permanent colleagues. There are actually around 60 different automatically unfair reasons under UK law. Other examples include being dismissed because you're a trustee of an occupational pension scheme, taking time off for jury service, or asserting rights under the working time regulations. So even if you're brand new to a job and don't yet have the qualifying period for ordinary unfair dismissal, if your employer fires you for any of these protected reasons, you can bring a claim to an employment tribunal. And these claims often result in substantial compensation, particularly discrimination and whistleblowing cases, because tribunals take them very seriously. All right, so let's say you've crossed that qualifying threshold. Currently, that's 2 years, but from January 2027, it's 6 months. What does protection against unfair dismissal actually look like? Once you have the required service, your employer cannot just fire you on a whim. They need 2 things, a fair reason and a fair process. Let me break down the 5 potentially fair reasons an employer can use to dismiss you. 1. Capability or qualifications. This means you're unable to do your job properly, either because you lack the necessary skills or qualifications, you're persistently underperforming, or you have a long-term illness preventing you from working. But even with capability issues, your employer must give you support, training, reasonable adjustments if you're disabled, and usually warnings before dismissing you. 2. Conduct. This covers behavior issues like persistent lateness, repeated rule breaking, or serious misconduct such as theft, violence, or fraud. Except in cases of gross misconduct, which I'll explain shortly, your employer must follow a disciplinary procedure with warnings before dismissal. 3. Redundancy. If your specific role is no longer needed due to business closure, restructuring, new technology, or reduced demand for particular work, redundancy can be a fair reason. But there are strict legal requirements about how redundancy must be handled, including proper consultation, fair selection if choosing between employees, and paying statutory redundancy pay if you have 2 years' service. 4. Statutory restriction. This applies when continuing to employ you would break the law. A common example is a delivery driver who loses their driving license. If driving is essential to their role and there's no suitable alternative work, the employer may fairly dismiss them. 5. Some other substantial reason. This is a catch-all category for legitimate business reasons that don't fit the other 4 categories. Examples include an irretrievable breakdown in working relationships, business reorganization requiring contract changes you refuse to accept, or, in some cases, pressure from customers or clients. But this reason is harder to prove and must be genuinely substantial. Now here's the crucial part. Even if your employer has one of these potentially fair reasons, they must follow a fair procedure. This normally means properly investigating the issue and gathering evidence, informing you in writing of the allegations or concerns, inviting you to a meeting where you can respond and give your side, giving you the right to be accompanied by a colleague or trade union representative, considering all the evidence and your explanations fairly, allowing you to appeal the decision to someone more senior. If your employer skips steps, rushes the process, or doesn't genuinely consider your responses, even a potentially fair reason can become an unfair dismissal. The process matters just as much as the reason. But there's one major exception to the notice and warning requirements: gross misconduct. Gross misconduct is extremely serious wrongdoing that fundamentally destroys the trust and confidence between you and your employer. Examples typically include theft, fraud, or deliberate falsification of records, physical violence, bullying, or serious threats towards colleagues or customers, being under the influence of alcohol or illegal drugs at work, serious breaches of health and safety that endanger others, gross negligence causing significant loss, damage, or injury, serious breaches of confidence or data protection. In cases of gross misconduct, your employer can dismiss you immediately without notice and without pay in lieu of notice. This is called summary dismissal. But here's what many people misunderstand. Even with gross misconduct, your employer still has to carry out a proper investigation and give you a fair hearing before making the final decision to dismiss you. They can suspend you on full pay while they investigate, but they cannot just fire you on the spot without any process, even if they've caught you red-handed. You still have the right to be told what the allegations are, to attend a disciplinary meeting, to respond to the accusations, and to appeal. And if they get it wrong, if they accuse you of gross misconduct without proper evidence or without following a fair procedure, that dismissal can still be challenged as unfair. Employment tribunals will look very carefully at whether the employer had reasonable grounds to believe gross misconduct occurred and whether they investigated thoroughly before deciding. So gross misconduct gives employers the power to dismiss without notice, but it absolutely does not give them the power to skip fairness and due process. So what should you actually do if your employer fires you without warning? Step 1. Stay calm and ask questions. Ask why you're being dismissed. If they won't tell you clearly in the meeting, follow up in writing requesting a full explanation. Step 2. Request written reasons for dismissal. Under current law, if you have 2 years' service, your employer is legally required to provide written reasons within 14 days of you requesting them. And from January 2027, this right extends to anyone with 6 months service. Put your request in writing. Step 3. Check your employment contract and employee handbook. Look at what your contract says about notice periods, disciplinary procedures, and dismissal processes. Also check the company's own policies. If your employer didn't follow their own stated procedures, that can strengthen an unfair dismissal claim. Step 4. Calculate your exact length of service. Work out precisely when your continuous employment started. Check your contract start date. If you're close to the qualifying period, every single day counts. If you're just under 6 months or just under 2 years, double-check the dates carefully, because even a difference of days can be crucial. Step 5. Consider whether any automatically unfair reasons might apply. Even if you don't have the qualifying period, think carefully about whether your dismissal might be connected to discrimination, whistleblowing, asserting a legal right, health and safety concerns, trade union activities, or any of the other Day 1 protections. If there's any connection, you may still have grounds to claim. Step 6. Gather all evidence. Save emails, text messages, performance reviews, witness statements, anything documenting what happened. If colleagues witnessed unfair treatment or can confirm what was said, ask if they'd be willing to provide written statements. Evidence is crucial. Step 7. Contact ACAS early. ACAS, the Advisory, Conciliation, and Arbitration Service, offers free, impartial advice about employment rights. They can help you understand whether your dismissal might be unfair and what your options are. Call their helpline on 0300-123-1100. Step 8. Be aware of strict time limits. This is critical. If you want to bring an employment tribunal claim for unfair dismissal, you normally must start early conciliation through ACAS within 3 months minus 1 day from your dismissal date. This is usually calculated from your last day of work or the date your notice period ended. Missing this deadline can mean losing your right to claim entirely, so don't delay seeking advice. Step 9. Consider legal advice. For advice specific to your individual situation, consult a qualified employment law solicitor. Many offer free initial consultations. Some work on no-win, no-fee arrangements for strong cases. Trade unions also provide legal support to members. So, can your employer fire you without warning in the UK? The answer right now in April 2026 is, it depends on how long you've worked there. Less than 2 years service. In most cases, yes, they can, unless they're dismissing you for an automatically unfair reason, like discrimination, whistleblowing, or asserting a legal right. 2 years or more service. No, they need a potentially fair reason, and they must follow a fair procedure. If they don't, that's unfair dismissal, and you can challenge it. But from January 1st, 2027, the qualifying period drops to just 6 months, meaning far more workers will have protection against unfair dismissal. Knowing where you stand legally is the first step to protecting yourself at work. Understanding your rights means you're not powerless, even in the most difficult employment situations. If you found this helpful, subscribe for more UK workplace law explained simply. We post new videos weekly, breaking down your employment rights in plain English. And remember, this video is for general educational purposes only and does not constitute legal advice. For advice specific to your individual circumstances, consult a qualified employment law professional in the UK. Thanks for watching. Know your rights.